David Spring's arrest and 18-month jail sentence for violent disorder was on the apparent basis of police bodycam footage, something which I pointed out in the last video, although some people tried to claim that I was hiding the fact, which wasn't the case, and which the Met Police have not released. However, we can now clear up any and all misunderstandings about that. That previous video, which I also put on Twitter and which generated a very large engagement, which is why inevitably it drew out a few haters, also elicited a new photo and a witness to the police bodycam footage. This is the photo. It's a bit more edgy and expressive than the previous ones we'd seen. And we have a court report, which doesn't really add much to what we already knew, but we can now see the whole thing through the eyes of the court reporter, who was there in court to see the bodycam footage, and then the picture is entirely complete. I'll run through that and then I'll pull the whole thing together. Retired train driver jailed after jabbing finger at police and shouting who the F word is Allah. That headline really is it, the sum total. We could stop there. But for the sake of thoroughness, on Tuesday, August the 13th at Inner London Crown Court, Mr Agbamu played TV coverage of the demo from Sky News and police body-worn camera footage that showed Spring shouting obscenities at police officers. Wearing a short-sleeved Ralph Lauren shirt and black backpack, Spring could be seen screaming effing W words and C words at officers in riot gear, then singing you're not English anymore. At one point he also joined the Islamophobic chant who the F word is Allah, 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 which is a popular song among far-right marchers. You can imagine the picture. This is the exact location, crowd facing riot police, and he's there pointing at the cops. Effing W words, effing C words, chant this, chant that, and that's it. He's not arrested at that point. He could have simply wandered off as far as I can see. And then the rest plays out as you saw in the last video, at the end of which he's arrested. So, armed with all that, Judge Benedict Kelleher was also asked to consider Spring's caring duties for his wife, who fell ill with pneumonia last year, but told Spring severe sentences were needed to deter others, as he chose to not suspend his 18-month sentence and send him straight to prison. He could have been given, along with a criminal sentence, which is no small thing, a suspended sentence, possibly in recognition of the fact that he was a carer, but he wasn't. At the point you did that, you must have been well aware it was a particularly volatile situation and police were doing their best to keep order. Your actions showed a complete contempt for the police at that time, said the judge, adding, what you were doing could, and it appears did, encourage others to threaten the police and add to the disorder. Are we reduced to contempt for the police? And that, when we know that the police tossed around one woman and threw her to the ground and said about a bloke in a gang and punched him to the ground. May he not have contempt for the police at this point? Well, for one thing, they don't really have too much else. And I suppose those assaults on the part of the police did come after his shouting and swearing. So maybe a more rational approach would have been something like, in the light of the whole thing that played out, I'm going to give you a pass on being contemptuous about the police. Giving his reasons for the jail sentence, Judge Kelleher added, violent protests can't be tolerated, and neither can violence towards police officers who do their duty to protect the public from disorder, and those who do can expect to receive severe sentences to punish you and deter others from disorder. Violence towards the police. There was no contact on the part of David Springs. There was subsequently an awful lot of contact on the part of the police, but absolutely none from him. And the sentence for the crime, which we have 100% a picture of now, we have in effect seen the police bodycam footage, was as much a deterrent as anything else. So, on to the crime. It is contained herein, where 3 or more persons who are present together use or threaten unlawful violence, and the conduct of them taken together is such as would cause a person of reasonable firmness present at the scene to fear for his personal safety. Each of the persons using or threatening unlawful violence is guilty of violent disorder. Are the police in riot gear held to have feared for their personal safety on account of this interaction with David Spring? They don't actually need to. No person of reasonable firmness need actually be or be likely to be present at the scene. That's fine, it's a generic standard, but it's also ironic that nobody present, the riot police, realistically feared for their personal safety when you're convicting somebody for causing somebody to fear for their personal safety, and to the tune of 18 months. It's at least rather ironic and possibly extremely excessive. A person guilty of violent disorder is liable on conviction on indictment to imprisonment for a term not exceeding 5 years, or a fine, or both, or on summary conviction for imprisonment for a term not exceeding 6 months, or a fine not exceeding the statutory maximum, or both. So he could have been given a fine, or, as the judge said, a custodial sentence but suspended. But the judge rejected that. He chose not to suspend his 18-month sentence and send him straight to prison. So, a man shouts and swears at the police and chants his chants. There is no arrest at that point. He witnesses thuggish behaviour from the police. He sees a woman being tossed around and thrown to the ground, and a man being inexplicably punched to the ground. He's literally right there. Unadvisedly at that point, as it turns out, he walks towards them with his arms outstretched and is arrested at that point and sentenced to 18 months in prison. I don't think the conviction can be appealed because he pleaded guilty, and the reason he pleaded guilty is because he had no choice. It was a choice between either pleading guilty or pleading not guilty, being found guilty, and then being given an even longer sentence. I believe he could, in theory at least, appeal the sentence itself, which at 18 months custodial and not suspended, and not also a fine, which the judge did have as an option, is obviously out of any proportion whatsoever, and down to a judging system which is currently off its head with power lust, thanks to the current unexpected opportunity they have to flex their muscles and clamp down on the people they really despise, the dirty lower classes, working classes, whatever, and on this occasion be able to sell it to the public, thanks to images of immigrant hotels receiving visits from protesters being fresh in the minds of the public. At the moment they can get away with it, and while they can, they will. But it's also an opportunity for those dirty working classes to see the establishment with their masks off, which is something the establishment would rather wasn't the case. They'd rather hide behind their masks, but while the upside is crushing the proles that they despise, they'll kind of take the trade-off. How it all ultimately turns out is anyone's guess, but in the meantime you've got a fella in prison for 18 months for, in reality, being the kind of person that the establishment class despises. Because if the reality was simply about the severity of the crime, then it would have been a suspended sentence or a fine, because that would have been proportionate. The sheer disconnectedness of the sentence shows you what this thing is really all about.